Hi, this is Matt with the Fortress Law Group, where we defend good people accused of bad things. In this video, we're going to be covering everything you need to know if you're facing an OVI charge in Ohio. We know that facing an OVI charge can be a daunting experience. Our mission is to help you navigate the legal process, protect your rights, and seek the best possible outcome for your case. We're going to look at the implications of OVI arrests, their penalties, and some possible defense strategies that we've pursued in the past in these sorts of matters.
Our team at the Fortress Law Group have been trusted allies in the criminal and OVI defense business in Ohio for over 14 years. We've handled hundreds of OVI cases and helped countless clients secure favorable outcomes for their cases, from reduced charges to case dismissals.
An OVI or DUI charge can make a serious impact on your day-to-day life. If you're convicted of an OVI in Ohio, it will leave a permanent stain on your record with no future possibility of expungement or sealing, which is why it's very important to act fast and hire an experienced OVI attorney who can help you avoid long-lasting consequences. Before we dive into the facts about Ohio OVIs, let's first cover the do's and don'ts of a traffic stop. Before you ever face this situation, you should understand how to act when a police officer pulls you over. Your actions can significantly affect whether you're charged with an OVI or DUI and what the penalties might be. First, pull over safely to the side of the road as soon as an officer signals you to do so. Remain calm and polite. Most importantly, you should not volunteer any information to the officer. Just like in a criminal case, people like to try to help themselves by trying to talk to the police. They'll say, for example, "I only had a couple," or "I didn't drink that many." But what happens then is that statement comes into trial as an admission to drinking. It gets subtly shifted and it ends up hurting the person. The best thing to do, just like in a criminal case, is just not make any statements at all without talking to an attorney. While the terms DUI, DWI, and OVI may be used interchangeably, they all essentially refer to the same thing: operating a motor vehicle while impaired by alcohol or drugs. In Ohio, the actual legal term is OVI. When you're suspected of driving under the influence, the investigating officer may ask you to submit a chemical sample to determine your blood alcohol level, or BAC. The most common methods that law enforcement officials use to chemically test a suspected impaired driver are breath tests, urine tests, and blood tests. The breath test is administered with a tool called a breathalyzer. This type of testing is generally used when someone is suspected of drinking and driving. If a person is transported to the hospital or suspected to be under the influence of drugs while operating a vehicle, a urine or blood sample may be taken. In Ohio, the legal BAC limit is 0.08% for drivers aged 21 and older. For drivers under 21, the limit is 0.02%. Ohio has two tiers of OVI offenses, which we call low-level and high-level OVIs. A low-level OVI is when the BAC is between 0.08 and just under 0.17%. A high-level OVI is 0.17% and higher. We'll discuss the differing penalties later on in this video. There are three standardized field sobriety tests in Ohio. The first one is called the HGN, which stands for Horizontal Gaze Nystagmus. The Horizontal Gaze Nystagmus test is the one where the police officer moves a fingertip or a pen in front of your eyes. They're checking for the small involuntary jerking movements of the eyes that can occur if a person is intoxicated. The other two standardized OVI tests are called the walk and turn and the one-legged stand. Walk and turn is the one where they have the person walk a line, and the one-legged stand is where you stand on one leg for 30 seconds.
In an OVI trial, the prosecutor will typically play the dash cam video of the stop. This video will show all the standardized field sobriety tests, including how the officer administered the tests and the client's performance on the tests. One thing that's not admissible at trial is the portable breath test. Instead, the officer will have to take you back to the station and have you blow into the machine at the station for that result to be admissible at trial. If they just give you the portable test on the side of the road, that's not admissible in court.
You have the right to refuse any of these tests, but it's important to understand that refusing an evidential breathalyzer at the police station will result in an automatic 1-year license suspension. A first-time OVI offense in Ohio is typically classified as a first-degree misdemeanor, which carries a range of penalties. Ohio law mandates a minimum jail sentence of 3 days for first-time low-level OVI offenders and 6 days for high-level OVIs, with a maximum sentence of up to 180 days. However, first-time OVI offenders may be required to attend a 72-hour driver intervention program instead of serving the minimum 3-day jail sentence. A first-time OVI offender can expect to pay a minimum fine of $375 and a maximum fine of $1,075. A first OVI offense in Ohio will result in an administrative license suspension ranging from 1 to 3 years and a court suspension of 6 months to 3 years. Reinstating your driver's license will cost you $475, and you must provide proof of insurance. Speaking of insurance, OVI offenders can expect a significant increase in their auto insurance premiums and may be required to obtain high-risk insurance. If the first-time OVI offender is convicted, the court may order the offender's vehicle to be immobilized for up to 90 days and the license plates impounded and replaced with yellow plates. In some cases, the court may require the installation of an ignition interlock device on the offender's vehicle, which prevents the vehicle from starting if alcohol is detected on the driver's breath. Keep in mind that these penalties are for first-time OVI offenders in Ohio. The court may impose additional penalties or requirements at its discretion, and the minimum penalties become more severe for repeat offenders. Ohio utilizes a 10-year look-back period to determine the number of prior OVI convictions. Offenses that occurred within this 10-year window contribute to the determination of penalties for a new OVI charge. If an individual is convicted of a second OVI offense within a 10-year period, they face more severe minimum penalties than for a first offense. A third OVI offense within a 10-year period is treated even more seriously, and if an individual is charged with a fourth or subsequent OVI offense within a 10-year period, it is considered a felony offense. Felony OVI offenses carry the most severe consequences, including a longer prison sentence, higher fine, and a potentially permanent license suspension. If you are facing a first-time OVI charge in Ohio, seeking legal representation from an experienced Ohio OVI lawyer is critical. Some common defenses we pursued in OVI cases include challenging the traffic stop. If the police officer did not have reasonable suspicion to initiate the traffic stop, any evidence obtained during the stop may be inadmissible in court. Challenging the field sobriety tests. Field sobriety tests can be unreliable, and an attorney may argue that the tests were not properly administered or that the results were inaccurate. Challenging the chemical test results. An attorney may question the accuracy of the chemical test results, including the proper calibration and maintenance of the testing equipment, the qualifications of the person administering the test, and any possible contamination or mishandling of the sample. Medical conditions or prescription medications. Certain medical conditions or prescription medications may cause symptoms similar to intoxication or affect the results of a chemical test. Diversion programs and plea bargaining. In some cases, first-time OVI offenders may be eligible for a diversion program or a reduced charge through plea bargaining. These options can help minimize the impact of an OVI charge on your life and may result in a dismissal of the charges upon successful completion of the program or probation. If you've been accused of driving under the influence, there are steps we highly recommend taking early on to protect yourself. The most important and proactive thing you can do is hire an experienced OVI attorney. Once again, do not talk to the police. Anything you say can and will be used against you. Don't drive illegally if your license has been suspended unless the court grants you privileges. Be polite and respectful to all court officials and follow court orders, and show up to court appearances and dress well.
Before we wrap up today, I want to leave you with a crucial reminder about the potentially life-altering consequences of an OVI conviction. Given that this conviction is not eligible for expungement or sealing, it's not just about fines and license suspensions. It's about the lasting impact on your life and your future. But there's good news. You don't have to face these challenges alone. A skilled OVI attorney is your ally in navigating the legal complexities, crafting a solid defense, and working to help you avoid the harsh repercussions that come with an OVI conviction. Don't let one mistake.
If you found this video resourceful or maybe learned something new that you didn't know before, Like and subscribe for more content on Ohio criminal defense. If you want to know more about Ohio criminal law and the Fortress Law Group, check out our website at fortresslawohio.com. This has been Matt with the Fortress Law Group. Thanks for tuning in.